Hey everybody, I'm going to be answering the question today, when do patents attack? I'm JD Houvener, owner and founder and patent attorney at Bold Patents Law Firm, also the author of Bold Ideas, the Inventor's Guide to Patents. I've helped thousands of inventors go through the process of applying for, researching, and actually getting the patents granted, and have over 300 patents issued for our clients as of today. I'm excited to talk to you about patents attacking. And maybe you were lured in by the topic, or you saw the thumbnail or something that was intriguing about, well, what do you mean attack? And so there's a couple topics I want to bring up here. First is, patents can be aggressive. When you have a patent that's granted, okay, as the patent holder, that is your job, is to be the police. And you're the one on the hook to be responsible to go find and look for infringers. There's no police, right? There's no patent cops. The USPTO is not going to go out and find, oh, you're infringing, right? You're the owner of the right. And it really is not more like a sword or a weapon against others, right? It's actually more of a shield, okay? You have the right to exclude others, prevent anyone else from making, using, or selling or importing your invention in the country. So the way to go about that is to monitor, right? Look at your competition. Once you're selling in the marketplace, you won't want to have your head in the sand for obvious reasons. From a business perspective, you would never want to ignore your competition, or, I should say, not go through the process of how your price compares to what the market is bringing. You should know where you're at in terms of the consumers you're serving and where your price point is. To that end, you should also look at what your competitors are selling to see if it might be infringing on your patented claims. If you think it's close and you're worried that, hey, someone else is copying me, they're ripping me off, that is sort of an emotional reaction. Typically, there's more nuance there, and it's worth your time and money to go hire a patent attorney to see, is there really infringement happening here? Is what they're selling truly, right, objectively meeting all of the elements of the claim language of your utility patent? That takes a careful eye, and a professional patent attorney can help you put together that opinion. If there is indeed, if your patent attorney says, you know what, this is something we can move forward with, that's when you can attack. And you want to start in a sophisticated way. You don't necessarily want to just immediately file in federal court a suit. That would be probably, in most cases, inappropriate. The best way to attack would be to think about, okay, who is this individual or company that's infringing? How can I make the best of the situation, right? One, not have to spend a ton of legal fees and get the best result in the end, which is making money and be able to sell my product so that they're not having, in other words, maybe a lesser quality or another brand offer the same product. And so sometimes a creative solution can be brought up with your patent litigator. These solutions might be, oh, you know what? I'm going to reach out personally and just mention, hey, you know what? Did you know that I've got a patent on this product? And I see you've got a great brand here. Maybe there's a way we could work together and allow you to keep selling. And you have to just simply pay me a royalty in return. That way there's no disruption to your business. We get paid and compensated for coming up with this invention, and we both can coexist and serve our specific market segments. That's a great solution, right? Maybe another solution could be where you partner, and now you find out that they have a way to make the product way cheaper than you do. Now you can be like, hey, can I use your manufacturer? And so long as you're willing to pay me a royalty, we can have alignment and even cross-sell to get more products in the hands of consumers and make money overall. Yes, of course, if those efforts don't work, you will need to threaten suit. And this more often than not will happen with what's called cease and desist letter. You're telling them, hey, you know what? Stop. Cease. You've got to stop infringing. Stop making, stop using, stop selling, and importing this product into the country. And if you've done enough of that type of information in that letter, you need to lay out your story, right? Lay out briefly why you think they're infringing. And if they continue to go down this path of either ignoring you or infringing, now you've got to go actually file in federal court a claim. And so this is when you need to hire a patent litigator to go through the process of all the right steps for the procedures, make sure it's filed in the right court, look at all the rules regarding jurisdiction and so forth. Anyway, so this is when patents can attack. There's one other area where patents can attack, and I'll get to it in a separate episode. And they get a bad rap. This is the patent trolls, okay? Where they're saying that they're attacking, but truly they're just defending their patent rights in a similar way. So let's talk about patent trolls later. Thanks for watching about patents attacking and learning about cease and desist letters and patent infringement. I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm. Wish you a great day. And if you have time, please click below. I've got a PDF for our Patent Inventor Kit. This is a free downloadable PDF for you to look at, see if it's information that might be helpful for you to make a decision about getting started today. All right, everybody, have a good day. Go big, go bold.